Duncan says, if you want to know about business, health, and places to go, welcome to the show. Yeah, welcome to the show. If you know that you want to grow your business, your practice, and portfolio, welcome to the show. Yeah, welcome to the show.
Hello, and welcome to I'm Simply Saying, the healthcast where the spine meets strategy, alternative healthcare takes center stage, and we discuss how to build thriving medical clinics. I'm your host, Dr. Mary Frances Duncan, founder and CEO of Simply Southern Chiropractic Center in South Carolina. I'm a chiropractor by trade in an entrepreneur's body. I'm excited to guide you through this journey at the crossroads of chiropractic care, integrative medicine, and the art of successful clinic management. Lastly, if you take anything away from this episode today, please leave this podcast a 5-star review. Reviews allow us to hear from our listeners and what interests you. So, without further ado, let's get into the backbone of it all. Welcome to I'm Simply Saying. Hello, everybody. I'm Dr. Duncan, and thank you for joining us today. In this episode of I'm Simply Saying, we are talking about car accidents and what to do if you are in one. So today we have a special guest. It's my husband, Will Maxey. He's a personal injury attorney here in Greenville, South Carolina. So will you just tell us a little bit about yourself, Will? Thank you for being on today.
Well, sure. Well, thanks for having me. I appreciate it. Happy to be on the show. Tell you a little bit about myself. I mean, as you mentioned, I'm a personal injury lawyer here in Greenville. I'm a partner in my own law firm, Maxey McFarland Law Firm. Our office is located near the Bon Secours Wellness Arena in downtown Greenville. Prior to that, I was a prosecutor. I worked at the solicitor's office, both in Spartanburg and in Greenwood counties. I went to the University of South Carolina for law school, but I went to Clemson for undergrad. And as anybody who knows me at all knows, that's not a difficult decision for me on Saturdays. Huge Clemson fan, huge Braves fan for anybody that has the misfortune of being friends with me on social media, constantly updating everybody about that. But that's pretty much all there is to know about me.
Well, just tell us a little bit about why you're a personal injury attorney and what got you into this field.
Sure. I knew that I wanted to be a personal injury attorney before I went to law school. I've always been somebody that has identified with the underdog from a very early age. At first, things as trivial as sports, but really, my whole worldview. I've always been interested in, sticking up for the little guy, so to speak. People who do not have the opportunity to stand up for themselves, especially when they're faced with, a sophisticated adversary such as the insurance industry, multi-billion-dollar companies who have, armies of adjusters and investigators and insurance defense lawyers. And it's incredibly gratifying to know that one person and one lawyer can make all of those people show up to the courthouse and answer for what they've done. And that's something that's unique about America, something that's unique about, the common law system. And frankly, it's a beautiful thing. The courthouse and access to the courthouse for anybody who's been wronged by somebody is one of the underpinnings of our democracy. And it's incredibly rewarding and an honor to be able to participate in it every day on behalf of my clients.
Well, thank you so much for being on today. And so let's just sort of get started here. And for our listeners, will you tell us what is personal injury and how is it related to car accidents?
Well, I appreciate you starting me off with a pretty easy question there. Car accidents are intertwined with personal injuries all the time. In fact, in my practice, the most common type of personal injury claim stems from car accidents. That is by far the most common type of personal injury case that I see. Cars, despite something that we use every day, on our way to work, on our way home, with our families traveling. They are incredibly dangerous, and even a slight bit of inattention can lead to significant collisions and injuries, and sometimes, unfortunately, worse.
Okay, well, to get started, I'm going to ask you some questions that I get on a regular basis from some of our patients. So, when hopefully no one that's listening is in a car wreck, but if you are, either it's going to be your fault or it's not going to be your fault. So, we're in the state of South Carolina. So, Will, can you tell us why fault is important?
Well, for you to prevail on a personal injury claim, in other words, win, as most people would like to say, you need to prove that it's the other driver's fault. Either that they did something they shouldn't have been doing, or they did not do something that they should be reasonably expected to do. Whether that's they ran a red light, which they shouldn't have done, or they weren't paying attention, which they should have been doing. Any of those things are things that you can use to prove fault or liability, as the legal term of art goes. Whether that's they rear-ended you, they ran through a red light, they changed lanes into you. You need to be able to prove that the other driver did something either to violate the traffic laws or that a reasonable driver would not be expected to do.
Well, say our patient, they were at fault. Say they hit someone else, they caused a car accident. What should they do? What steps should they take after this accident?
Well, some of the steps that you take after a car accident are the same, regardless of whether or not the car accident was your fault. First of all, depending on how serious the car accident is, you need to move your car out of the road if you can, because you don't want to get hit again. Now, if you're in a serious collision where there's serious injuries, whether it's you or another party, your car is disabled, you may not be able to do that, or it may not be appropriate to do that. But in the most common type of crash, where you will have some damage to your car, but you can move it out of the road, go ahead and get over to the side of the road, get out of the way. That way nobody else hits you and you don't suffer any other injuries. If it, You asked me if the wreck is your fault, I'm imagining a scenario where it's pretty obvious that it's your fault. In other words, you've hit somebody from behind, or you ran a red light by 3 or 4 seconds, where it's clearly your fault. What you should do is if you can get out of the car, go see if the other driver's okay. You don't need to say I'm sorry. You don't need to say I wasn't paying attention. I was on my phone. Like you don't need to say anything like that. But you do need to go over and say, "Are you okay? Do I need to call an ambulance?" And then see what their response is to that. You need to show, first of all, because it's the right thing to do. But secondly, you need to show some kind of concern to the other driver. Because if you don't go check on them, and God forbid you get sued, the case goes to trial, as a plaintiff's lawyer, I would love to be able to get up there and say, well, you didn't even check on them. You didn't even
Mm.
care enough to walk over there, 15, 20 steps over there and see if the person that you hit was okay. Now, I'd probably get an objection for a leading question like that, but that would be the point. Is I would be showing that you were indifferent to them. So it's important that, again, just being a decent person, that you go check on the other driver and make sure they're okay. But also, you need to demonstrate that you are concerned about them for that purpose as well.
So show concern, but don't admit fault.
Correct. You shouldn't say, I'm sorry. You shouldn't say, I didn't mean to do that. You shouldn't say anything that would appear to admit any sort of liability or fault on your part. It is human nature. I mean, even sometimes, with really minor things, like you bump into somebody at the grocery store, you go, ooh, I'm sorry. Like, things like that, you got to be very careful about what you say in the moments right after an accident. And once you verify that the other driver's okay, and of course, relatively speaking, right, they may be injured, but they're not in dire need of medical attention. If they are hurting, or if they did say that they needed medical attention, by all means, go ahead and call 911. You can report the accident that way. You can also report a car accident by dialing, at least in South Carolina, you can report a car accident by dialing star HP, which will contact the Highway Patrol. And then what you need to do is you need to get your license, your registration, and proof of your liability insurance together, because the officer will ask for that whenever he or she arrives on the scene. When the officer gets there, the officer's more than likely going to ask you what happened. And it's very important that you be very careful about what you say in this scenario. Now, he may not be recording. Now, some of them do have body cams these days. He may have that running, or he may have a dash cam running. So you should assume, even though you don't know, that you're being recorded. So what you need to do is you need to tell them very simply what happened. Don't speculate. Don't guess wildly about what you think they were doing or what they should have been doing. And certainly don't take this as an opportunity to vent your anger at the other driver. You just need to very calmly and carefully tell the officer what you saw and what happened. You tell them what happened and tell them the truth, obviously. I mean, that shouldn't need to be repeated. But you tell them the truth, you tell them what happened, and then you stop talking.
Well, what happens, like you said, it's human nature. If the accident was your fault and you do tell the person that you hit that you're sorry, and it's just that language just starts coming out, what do you do then?
Well, admitting fault or admitting liability isn't the end of the world in a car wreck case. In fact, sometimes a jury can look favorably upon someone who's willing to admit liability or admit fault. They could say, look, she said she was sorry. Her lawyer said they were willing to pay for his medical bills, but that they didn't think it was fair that the plaintiff should get all this money on top of that. That can be a very effective way to defend a car wreck case, especially in a conservative area like ours, where jurors don't tend to give large personal injury verdicts. Sometimes the best thing you can do is sort of to use the saying "fall on your sword," is to just say, "Look, I'm sorry. I did not mean to do that. I shouldn't have done that. I'm sorry." Sometimes that can be a good thing. But what I would avoid doing is saying that before you even know all the facts, right? Because all you know is what you saw in your car. There could have been, there just has been no investigation of anything. You have no idea what the other driver's up to. Perhaps the other driver's impaired, right? I mean, you don't know that. Maybe they've had too much to drink. Maybe they're high on marijuana. Maybe there's something that you or your attorney could use to defend yourself in this case. Something that you could point to and say, well, their reaction time was reduced because of this, and if they hadn't been doing this illegal thing, maybe they would have been able to avoid the accident. There are things that you don't know about at that stage. So, a short answer to your question is it's not necessarily the end of the world. But also, it can be a good thing too.
So, say one of our patients was in a car accident and it was their fault. So, in regards to medical treatment for our patients, so say they caused the accident, but they also are hurt. They have soft tissue injuries or any type of injury. How do they get that? Can they get those medical bills covered? Can they get that treatment covered? What are they supposed to do?
Well, just like anybody else who's injured, they need to seek medical treatment immediately, just because that's what they need to do for their health. As far as a car accident claim goes, and of course, fault is something that is not always immediately apparent. And also, the police report, just because the police say that it was your fault, they circle yes under contributed accident. That's not the end of the inquiry. That form is never going to be in evidence. The jury's never going to see it. If you have a witness that can say that the accident was actually the other driver's fault, there are ways that you can prove that it's the other driver's fault. So you don't have to, basically give up immediately because the police circled yes on the form. That doesn't mean anything. But if it is a situation where it's obviously your fault, right? There's not any logical argument you could advance to say that it was not your fault. Well, then what you need to do is you need to get the medical treatment that you need to have based on your injuries, and you need to do it as quickly as you can. But you need to understand that the other driver's car insurance is not going to be paying for it. And unless you carry personal injury protection or medical payments coverage, you may not have any kind of coverage on your vehicle that's going to help. So it's probably going to end up being your financial responsibility directly, or your health insurance coverage that pays for it, unless you have, like I said, personal injury protection or medical payments coverage on your car insurance policy. And that's a first party type of coverage that covers you regardless of whether it was your fault. Those kind of policies could kick in and pay, but most people in South Carolina don't have that.
Okay, so Tell us a little bit more. This will help our listeners and myself included. So, if we want to get extra protection for ourselves, what should we add to our personal car insurance policy and how much?
Well, what you need to do is you need to ask your insurance agent, whoever that is. Maybe you go to a State Farm agency and you talk to them, or you have an independent agent or broker. You need to talk to them about what you can add to your policy that will help protect you. They'll be able to give you the best advice. But what I would say, based on my experience, is you need to have things like underinsured motorist coverage, for example. That's a type of coverage that applies if the other driver, their insurance coverage is not enough to cover your damages and it's their fault. That helps boost the possible recovery that you could get by purchasing that coverage. You also need to make sure you have plenty of liability coverage for if the accident is your fault, because that's what protects you, your family, your assets, and your credit. If you have a situation where you cause damages for more than the liability coverage on your vehicle, and you may be thinking to yourself, well, if that's all the insurance there is, well, that's too bad. No, that's not true. If somebody tries a case against you and gets a judgment against you for more than your insurance company or your insurance policy will pay, more than your policy limits, you, the defendant, are on the hook for the excess. And the plaintiff can take whatever means that he or she needs to recover that. It's hard in South Carolina to recover a personal judgment against a judgment debtor. In other words, a defendant who has a judgment against them. But if they're able to do that, they could get to your house potentially. They could get to a boat if you own something like that. They could get to really any of your property that is subject to attachment.
So, it sounds like we all need to get some extra coverage on our car insurance.
Yes, yes. You need to get as much liability as you can afford. Now, look, at a certain point, it's overkill, right? If you're in your mid 20s and you don't own a home, you don't really own anything other than your car. You don't need to be going out there and buying $500,000 of liability insurance. I mean, you just don't. Now, you probably do want to get more than the state minimums because $25,000. Most of the time, if you get hurt at all and you go to the hospital, I mean, your hospital bills are going to end up being 15 or 16. So you need to have at least 50 or 100. Going much above that, I mean, doesn't really make a whole lot of sense if you don't own a home or don't own something to protect. But generally speaking, the more liability insurance you can purchase, the better. But other types of coverage that you can get that'll benefit you are things like collision coverage, comprehensive coverage, things that, regardless of if it's your fault, your insurance will kick in to fix your vehicle, or to pay you for the loss of your vehicle, if that's what happens from the accident. So collision coverage is of crucial importance, and in fact, a lot of times it's required by some lenders. If you get in a situation where you're financing your car, they want you to have collision coverage to make sure that they essentially make sure that they get their money back.
Okay, so talk to me about if you're in a car accident and it is not your fault. Say someone else hits you from behind or someone else causes a wreck. What are the steps that we should take if we are not at fault after a wreck?
Some of the steps that you'll take are going to be the same. You need to report the accident to your insurance company, regardless of if it's your fault. If the wreck is your fault, the insurance company is there to protect you and protect your assets. And if it's not your fault, if you have certain types of coverages that would help you in that situation, things like underinsured motorist coverage or uninsured motorist coverage, if the other driver doesn't have any insurance, you're going to want to go ahead and establish those claims. And you'd want to establish a liability claim if it looks like it is going to be your fault. But if it's not your fault, you especially want to make sure that you document everything you can. You take pictures of the accident scene. You take pictures of your car. You take pictures of their car. And it's easier now than ever before to do that because everybody's got a great camera on their phone. But you need to make sure you take pictures of both vehicles. Make sure you take pictures of the scene. And if you see any witnesses, any other drivers who stopped, you need to get their name and their phone number. And that's important because sometimes, even if the officer circles yes on the form for the other driver and says it's their fault, they contributed to the collision, you may have a witness that pops up, a year later in a litigation that says they saw you speeding down the highway. And, your lawyer or whoever's representing you can do the best job they can cross-examining that person to take away their credibility. But you really need to make sure that if there are other people who can substantiate what you said and what you saw, that you get those people's name and number. The police officer is supposed to do that, but I can tell you time and time again, I've seen car accidents where the police officer who responded just took everybody's name down, just kind of like, well, it seems like it's your fault. And then that's where he stops. He writes his report. He gives you the FR10, which is the form that they print out at the scene of the accident that has your name and address, the other driver's name and address, and both drivers' insurance company and policy numbers. Um, he just kind of ends the inquiry there. So if there are any other witnesses that you can see, you need to try to talk to them, see what they'll say, and get their name and number if you can. And you need to take the FR10, the form that I was just talking about, and turn that into your insurance company. Again, regardless of if it's your fault, because that has to be forwarded to the DMV as soon as possible after the accident. I think off the top of my head, it's 15 days that you have to turn that in. But your insurance company will forward that to the DMV for you. If it's not your fault and you have been hurt, you need to get to the emergency room as soon as you can to get checked out. It's common to say, or, oh, well, I didn't break my leg or I didn't break my arm. I don't need to go to the ER. I don't want to wait. I'll go home. And then, over the next day or two, you really start to feel some pain. You really start to feel pain in your neck or your back or any other body part from the accident. And at that point, you've already kind of given them something, them being the insurance company and the defendant, to argue about. Is if you say, "Oh, well, I'm not hurt, I'm okay," at the scene, and then you start saying you're hurt later, the longer that goes on, the better argument they have that, you weren't hurt or it wasn't serious or it couldn't have been that bad. Or at worst, if you wait long enough, they'll start saying that you're making it up. They'll start saying that it's not related to the accident at all. There's no way that's related. So you need to go to the emergency room if you're in any pain. Um, First of all, some of the scans they do at the emergency room could reveal a serious injury that you didn't necessarily know about. They could see that you have a broken bone or some injury that you weren't aware of. But also, it serves the purpose of documenting the injury, documenting your complaints that day. Because if you don't go and you end up, pursuing a personal injury claim, they're going to use that against you. They're going to say, well, clearly he wasn't hurt. He was walking around fine at the scene of the wreck. He multiple people asked him how he's feeling, and he said he was doing okay. Those are the kind of things they're going to say. So you need to get to the ER. I understand, especially for some of the folks listening to this who are, big believers in chiropractic, which I am too. I get regularly adjusted, but and those folks know that chiropractors are generally better at treating some of the injuries that you would get in a car accident. You still need to go to the ER because that way you've established that you were hurt, you did need medical treatment immediately, and you just go from there.
If our patients got hit, say, from behind and they know they don't have a broken bone, and in that moment they feel okay, they should still go to the ER?
Well, first of all, I would challenge the first part of that. Nobody really knows that they don't have a broken bone until somebody has looked. You need to get checked out. You need to make sure that that's the case. I mean, generally, people are going to know if they didn't break a bone or not. I agree with that. But, you do need to at least get that checked out. But if it's a case where for whatever reason, you just know or you don't want to go to the ER, yeah, that's okay. I mean, that doesn't mean you don't have a claim. I mean, you could go straight to your chiropractor that day if you wanted to. There's nothing wrong with that. It is just being honest. It is going to drive down the value of your claim. Not because if there's anything wrong with getting chiropractic care. In fact, that's very common in personal injury cases. But a lot of the valuation that goes into determining how much a car accident case is worth, for right or wrong, stems from how much you have in medical bills. And the logic that goes into that tends to be from both jurors and from insurance adjusters. Well, the more hurt you are, the more treatment you must have needed. So the more money spent on your medical care, the more hurt you must be. That's the logic that goes into that. It's faulty logic for reasons that I've argued many times, but it is true that that's generally going to be how they evaluate it. So I would say that you still need to go to the emergency room, but If you just absolutely are against that and you don't want to go, that's totally fine. You're well within your rights to go straight to your chiropractor, get checked out by your chiropractor, and get adjusted that day. There's nothing wrong with that, but you do need to understand that it may come with some negative impacts on your personal injury case.
Well, let me ask you, so if there's no other option than the ER, how about going to see your primary care physician or a medical doctor at an urgent care facility?
You can do all of those things too. There's nothing wrong with that either. But for the same reason, it may have a negative impact on your personal injury case. A lot of those offices are not going to be set up to do some of the scans they can do at the emergency room. And again, basically in South Carolina anyway, I don't really know of any defense lawyer that has ever really seriously pushed back on somebody's right to get checked out after the accident. If you go to the emergency room right after a car accident the day of, they are almost never going to challenge that bill. Now, one thing that I feel like unfortunately needs to be said, it shouldn't because it's obvious. If you're not in any pain or you're really okay, don't go to the emergency room. But if there's anything about you that hurts at all, or there's something that you feel uncertain about or feels uncomfortable after an accident, by all means, go and get checked out.
Okay, so now we know that we are supposed to go to the emergency room if we hurt at all. That's correct.
That's right.
And so, what happens if, a lot of times we get patients in our office and they don't feel anything the first day, and the stiffness and the strain pain sets in a day or two later. So, if a patient does think that they're not hurt after the accident, you still think they should go to the emergency room, or should
Well,
they go see their medical doctor?
I would say it all depends on how long it is after the accident. If it's the next day, I think it still makes sense to go to the emergency room. If it's 3 or 4 days later, I think it probably makes more sense to try to get into your primary care physician or go to your chiropractor if that's who you usually go to, because at that point it's harder to say that the injury is emergent, right? Something that you like desperately got to go to the hospital for, to the emergency room for. So I think it's sort of a sliding scale, right? The further you get away from the accident, the less sense it makes to go to the ER, and the more likely that if you end up in litigation, that treatment is going to be challenged by the defense.
So, talk to me about payment for people that are in car accidents and it's not their fault in South Carolina. So, who pays for this? Like, who pays that ER bill? Who pays, the chiropractic bill? How do patients handle this?
Well, that's a good question, and that's a question that I get every day at my office, meeting with current clients, new clients, and the answer is, lawyers love this, but it depends, right? It depends on if that person has health insurance coverage. If you do have health insurance coverage, oftentimes it's a good idea to use it. If you have personal injury protection or med pay, what we discussed earlier, it's a good idea for those policies to pay if you don't have health insurance for whatever reason, or you have access to that coverage, those could pay. But ultimately, what's going to happen is the other driver's policy is going to pay out. But the reason it's important to try to find ways to pay for it in the meantime is they're not going to pay out until the very end of the case. And what I mean by that is when you've reached what's called maximum medical improvement. Your doctors or the folks that are treating you have decided that they've done all they can do for you. This is as good as you're going to get. That's generally the point at which your lawyer, or you, if you're handling it yourself, which is a bad idea, but we can talk about that, gets all your medical records and bills, submits them to the insurance company with a letter demanding an amount of money for settlement, oftentimes the policy limits. And then at that point, they'll either pay those policy limits or they'll make you an offer less than that. And then after some negotiation, you'll agree to a settlement amount through your attorney or otherwise. And then they'll send you one check for the full amount. And so they do end up paying in the end, but you're going to have bill collectors, hospital people, doctors' offices after you in the meantime.
So, say there's a patient of ours, they're in a car wreck and they're supposed to go to the emergency room right after the wreck. Well, say they don't, have the funds right then to pay for the emergency room bill. Is that their only option, or?
Well, what's commonplace in situations where somebody doesn't have health insurance is to ask the hospital for a payment plan. Oftentimes, hospitals, emergency rooms are willing to take significant self-pay cash discounts, and then they're willing to break up those accounts into smaller payments so that you can pay something. But the best rule of thumb is, if you have a hospital bill in an accident, don't just sit there thinking that, oh well, their insurance is going to pay. Well, they are eventually, but they're not going to until the end of the case. Um, and so, you need to do something to make sure that they don't send that account either to collections or to somebody who's going to keep blowing you up about your hospital bill.
Okay, so our listener, they have gone to the ER. The ER, they can prescribe medication. Probably they're going to prescribe something for inflammation, maybe a muscle relaxer, especially if it was a soft tissue injury and there was nothing wrong with organs. There were no breaks, no broken bones. So what's the next step?
Well, unless you have some sort of philosophical objection to the medication they give you, or if they give you something narcotic, if some folks aren't able to take that. Absent that, you need to get whatever medications you were prescribed filled, and take those as directed by the doctor. Because if you don't do that, one of the things that'll happen if you do end up in litigation, you file a lawsuit, and they're going to subpoena your hospital records, and they're going to subpoena your pharmacy records. And if they see that you never even filled the prescription, and then your lawyer is trying to argue that you endured months of pain and suffering, well, they're going to say, well, you didn't even take your pain medication. You must not have been hurting. That's the kind of stuff they'll use against you. And you have a duty as the plaintiff to mitigate your damages. And what that means is to take whatever steps you can to lessen your damages. In other words, if you are in a lot of pain, you can't just sit around and do nothing about it and expect the defendant to pay for it. You need to get the medical treatment that you can get. And that's why what chiropractors do is crucial. Chiropractors offer the ability to get medical treatment, usually on a letter of protection or a lien, as they call it, in exchange for waiting to get paid at the end of the case. Because that way, that plaintiff can do what they need to do to get that treatment to mitigate their damages, without having to come out of pocket, on the front end.
So explain that. I don't know if our listeners understand what a treating on a lien means.
Sure. So it's very, very common for chiropractors to accept a letter of protection from an attorney, which is basically a letter where an attorney says, I will protect any interest you have out of the settlement funds. In other words, if there's a bill that needs to be paid out of the settlement, the lawyer will honor that. And a lien is close to that, but it's a little different because it's usually in South Carolina we don't really have statutory medical liens, but you do have things called assignments of benefits, which most people colloquially refer to as a lien, where the patient slash client will sign a document saying, I'm assigning you, Dr. Duncan, rights to my settlement whenever I should receive it, and I'm instructing by signing this, I'm instructing my attorney, whoever that may be, whether I hire one in the future or not, to basically honor your bill at the end of the case. And as long as the attorney is on notice of that and the client is on notice of that, and also you could, as a chiropractor, you could put the liability carrier on notice of the assignment of benefits. You'll be protected so that whenever something gets paid out, either the attorney has an ethical and professional responsibility to pay you, or the carrier will say, well, we've got this assignment, we got to take care of this. Because what you don't want to have happen as a provider is just have somebody floating around in the wind that got their car accident check and they're never going to pay you.
So for our patients, are they able to get treated on a lien at the ER if they're supposed to go to the ER after a wreck?
No, no. Hospitals, I've never had a hospital accept a letter of protection or say that they would just, wait on the end of the case. I've sent letters before to try to get them to do that. I call them a patient's letter, not like a patient apostrophe S, but be patient type letter, to say, hey, I represent John Doe. He's been in a car accident. He received treatment at your facility. I'm writing you to ask that you hold off any collection actions until the end of the case. Just please hold off, and we'll be sure to get in touch with you at the end. That did not work. They do not care. They will send that account wherever it is they send it if they don't get payment. I've never had that work with a hospital.
So, what other medical providers will typically treat on a lien?
Um, there are some doctors who will do it. There are some, a lot of chiropractic doctors will do it. S- Sometimes you'll see some PTs that'll do it.
Some
There's
physical therapists?
Yes, physical therapists. Some orthopedic surgeons. There's a handful that'll do that, usually through a medical funding company. Basically, a company who pays them, and then that company has a letter of protection with the plaintiff's attorney. That happens some, but it's pretty rare. Really, chiropractors are the only um, type of doctor that like regularly does that sort of thing.
So it seems to me that there's three ways that a patient that has been in a car wreck and it's not their fault can pay for treatment. They can just pay out of pocket themselves. They can file directly with, tell me if I'm wrong, the car insurance of the party at fault.
I mean, I don't know. I mean, you can send the bill to them. I mean, they might pay it, they might not. I mean, what they'll probably do is say, "Yeah, we'll pay that, but in exchange for a release." And then at that point, you'd have to sign a release saying, "I accept this money. I'm not going to ask for any other." Or they'll say like, "We'll pay for this, and we'll give you, up to $10,000 in medical treatment, but you have to sign this release, basically letting our insured off the hook. You won't come after him or her personally, and we'll give you $2,000 for pain and suffering." Um, First of all, you may be entitled to way more money than that under the law. But secondly, what they may do is say, well, because you take them up on that, right? You take them up on the $10,000 in future medicals. Say, well, I went to my chiropractor, a week and a half after this because I was still hurting. Well, at that point you have no recourse. The adjuster will say, well, sorry, that we don't think that was reasonable. You didn't need that, so we're not going to pay for it.
We see that a lot. Okay, so the third option that our patient may have is they can use an attorney. So tell us about that.
Sure. I think it's a good idea for anybody that intends to pursue a personal injury claim to hire an attorney. Your attorney can help you or help advise you as to how to proceed. They can advise you on the best way to get your medical treatment paid for. As we mentioned earlier, they may have the ability to get you treatment, especially if you're uninsured, on a letter of protection or using a lien, as we discussed before, if there are providers that will accept that. So it's always the best course of action to get your lawyer involved, so that way that he or she can give you the best advice on how to settle your personal injury case for as much compensation as they can get.
So, in your opinion, why should somebody hire an attorney? Or are they even hiring an attorney? Would the patient even pay you money?
So the reason you should hire an attorney is the way that insurance companies evaluate claims is in terms of risk. They're constantly trying to think of what's our worst day and what's our best day going to be. And for an insurance company, our worst day is pay the most money possible. Their best day is pay no money or a little money. And so anytime that you hire an attorney, that all shifts in your favor because the insurance company knows that you, as an injured person who's not represented and has no legal training, you don't understand the rules of civil procedure. You don't understand the rules of evidence. You never drafted a complaint before. You wouldn't know what all goes into that. You may not even know what the applicable statute of limitations is. You may not know how to file a lawsuit. So knowing all that, they know that you're not in a position to adequately represent your interests, in a worst case scenario, which is a trial, wherever a jury awards a large verdict. So if you have a lawyer on your side, all of those things shift in your favor, because then the insurance company knows that you have somebody with legal training, with experience in these type of things, who understand the rules by which that particular game is played. And they know that attorneys will know about things like general damages, like pain and suffering, things in addition to the amount of your medical bills. A lawyer will know that at the trial of a personal injury case, you'll be able to present the full amount of your medical bill and not just what you paid. These are all things that'll help increase the value of your personal injury claim, and all things that an attorney can help you with.
So, does our patient pay you up front? How do they pay for legal services?
That's a great question. So patients pay, or sorry, patients are in my world, clients pay me and personal injury lawyers like me through what's called a contingency fee. And a contingency fee is a percentage of any amount of money that's recovered on the injured person's behalf. So that means that if I take a case for a client and then we go to trial and I lose, which losing in a personal injury trial is getting $0, I don't get paid at all. So the reason we get paid on a percentage basis is because we are assuming the risk of the representation. The patient slash client never has to come out of their pocket to pay me my attorney's fee. Never has to come out of pocket to pay me my costs. Those are all things that are just taken out of any recovery that we get if we do get one.
So, our patients may be thinking, if I do this myself, I'll get more coverage or I'll get more for pain and suffering than if I used an attorney. Is this true?
No, for all of the reasons that I just listed. The insurance company is never going to pay you as much money as they would if you were represented. I mean, that's just a fact. They know that you are not equipped to handle that. They know many times what they try to do is what we discussed earlier. They'll say, "Oh, well, we'll pay you $2,000 for pain and suffering and $10,000 for any medical bills you might need." Well, once you sign that release and you have let them off the hook, and you have given up your ability to file a lawsuit, given up your ability to go to a jury trial, they now know that's their worst day. And then most of the part that they haven't even paid, you haven't had yet. So what that means is, they could then push back on you and say, well, we're not paying that because, this is not reasonable. This is not necessary. And at that point, you have no recourse to push back because you've already released them.
I've definitely seen that in our clinic. We either treat on a lien and work with an attorney, or the patient will just pay up front however they decide to do that. And then they can take the records and the bills and submit them to the car insurance to get reimbursed. And most of the time, they don't get reimbursed the full amount. So we do recommend in our offices in South Carolina for our patients to use an attorney if they were in a car wreck and it was not their fault. So let's talk specifically about car accidents and chiropractic care. So, is there anything you can tell us about when the patient should come into our office? What is the typical treatment? What are those typical treatment times for chiropractic care?
Well, your patient should get into your office as soon as they can. We talked about the emergency room and their doctor's office and all that earlier. And if they're diagnosed with a soft tissue injury, which is going to be, you're not going to go to the doctor's office and they're going to say, well, hey, Sam, you have a soft tissue injury. They're not going to say it like that. They're going to say, you have a myofascial strain, or you have a lumbar strain, or a cervical sprain. Any sprain, strain, muscle pull, muscle spasm, some of those type of injuries. Those are all what we call soft tissue injuries, because they, affect the soft tissues. These are not skeletal injuries, right? You're not breaking bones. These are not things, that require surgery. These are not things that have tears or anything like that. So those are going to be your soft tissue injuries. And so if you go to the emergency room and they say you have a cervical strain or lumbar sprain or thoracic strain, anything like that, any sprains or strains, and they give you your muscle relaxers or whatever, and those aren't working or those aren't helping, you don't even necessarily have to wait for that. If in a couple days or 2 or 3 days you're still hurting, you are well within your rights to go to your chiropractor, have your chiropractor treat you, and basically do what they can to get you back to MMI.
We definitely want patients coming in sometimes day of the accident. If they go to the ER, that's fine, but we want to see them. Especially, we want them coming in day one or day two. And so patients don't really know if they're in pain when they first come in. They'll experience a lot of stiffness, usually on the third day after an accident. Sprain strains are the number one thing that we see in our office after a car accident. Whiplash is very common. If you get hit from behind at all, you are going to experience whiplash, whether you feel it or not. And if whiplash is really bad, you'll have issues in the front of your neck where it's very tender and it's hard to swallow. especially if you got hit from behind, which is the most common thing that we see. And so we definitely want patients getting into our office, and it sounds like they need to go to their medical provider first, and then go ahead and get into our clinic, because the faster that we can see you, the more likely we are to get you better. And I also know that with these personal injury cases, the more quick that the patient gets into our office, the easier it is for the patient to probably get coverage for their medical treatment. Is that correct?
Yeah, yeah. I mean, you're not going to get as many questions from the insurance adjuster, or if you end up in litigation, from the defense attorney, if you're able to avoid treatment gaps. That's really the most important thing. Is you can never go wrong by getting to your chiropractor or medical provider as quickly as possible. You just can't have 2 week long, 3 week long, even week long gaps can be a problem sometimes, especially in the early days of the accident. But you need to make sure that you don't create any treatment gaps where they can introduce some doubt in the jury's mind that the pain you're complaining of is real, because they will do that. I mean, there is a lot of victim blaming and denial that goes on with this. They will try to say that you weren't hurting, you waited, you didn't get treatment. These are things that'll happen to you if you have treatment gaps. So you need to get in as quickly as you can, and you need to make sure, and this is just as important as getting in quickly, you need to make sure you go to all of your appointments. If you start skipping appointments, they're going to start being able to make the argument that maybe you aren't as hurt as you say you are.
Well, a lot of times with our patients, it takes about 2 months to reach maximum medical improvement. That's MMI. And so we usually see patients 2 or 3 times a week for the first month, and then maybe 2 times or even once a week in the second month. Is that pretty typical? Is that what you usually see for chiropractic treatment after car wrecks?
Yeah, yeah, I'd say that's very typical. I've seen more than that before. I've seen slightly shorter than that before, but no, I think 2 months for a chiropractor, for a course of treatment with a chiropractor is very typical.
So we'll sort of wrap this up here. So if a patient is using a personal injury attorney and they have completed their treatment at the chiropractic office, what are the next steps and what's the timeline on that?
Well, what you would do at that point is or what you could expect as a client, what your attorney would be doing is gathering your medical records and bills. Sometimes that takes longer than we would like, especially from hospitals or medical offices. Chiropractors are generally pretty good about turning them around quickly. But I would give your lawyer, I'd say 45 to 60 days from MMI, before you start kind of hounding him about it or hounding her about it, because it is going to take some time to get all of those things in. Usually, what I do is I try to get in the initial records and bills. So if my client comes in and hires me and they've already been to the ER or they've already been to their doctor, I'll go ahead and request that. But for everything else, I tend to wait until the end of the case, because you don't want to be piecemeal sending requests, because what will end up happening then is these doctors' offices don't look carefully at what they're doing as far as getting which records for you. And oftentimes what they'll do is they'll just give you the same records every time, and you end up paying for all these duplicate pages. And at some of the rates that they charge these days for medical records, that can get pretty expensive. So the best course of action is to request all of those things at the end, other than the initial records and bills, and that can take about a month and a half to 2 months.
I just have a question. On the patient side of things, can they request those records? Can you take records from them? Because I know that the medical doctor can't charge them for their records.
You can do that. That is something that you can do. Um, they, with the high tech rule, or that got sort of blown up in Congress, unfortunately. But it used to, the attorney could basically step into the client's shoes and make those requests, and either not pay very much money at all. I certainly never got them for free. But yeah, the client can do that. However, from the client side, or from the client slash patient side, you may not always know what you're looking for. You may not get everything that your attorney needs. Just handing somebody an after visit summary, or handing somebody like the little sheet you get in the mail that says your balance is X. That's not good enough. You need the bills with the ICD-10 codes. You need the full charts and notes, and you need, generally, the best idea is for your attorney to get all those things, because he or she knows what they're looking for.
Okay, well, anything else that you want to tell our patients about car accidents and chiropractic care?
Well, what I would say is that chiropractors do a wonderful job taking care of clients who suffered, from sprain, strain, soft tissue injuries. My clients that have had that have reported, great relief and good results from that, and frankly, more so oftentimes than physical therapy. What y'all do is an incredibly valuable service for my clients and for other attorneys' clients, and I think it's a great modality of treatment for people to seek if they've been in a car accident and they have those sprain, strain injuries. And I just think it's a wonderful thing for people to do generally, but definitely those who've been in a car accident.
Well, you heard it from Will Maxey himself. So thank you so much for being on this podcast, and we hope you learned a lot on today's episode of I'm Simply Saying.
Ding-a-ling-a-ling, ding-a-ling-a-ling.